And now we will continue with Jasmine Sommardal's talk titled Considerations which the court is not well equipped to challenge: the obligation of contracting parties to produce national security evidence before the European Court of Human Rights. And Jasmine Sommardal is a PhD researcher in human rights law and a coordinator of the Human and Fundamental Rights Working Group at the European University Institute in Florence, Italy. Jasmine, we're looking forward to your talk. The floor is yours.
Thank you so much. And I will start sharing my screen. Wait a second. And then let's see if I get my presentation going. All right, so my presentation relates to considerations which the court is not well equipped to challenge and the obligation of the contracting parties to the European Convention to produce national security evidence before the court. And I would first of all like to thank you so much for the possibility to speak here today and for all our good discussions that we've had. I think this presentation also has a lot of synergies with what we've been discussing lately. So what I also wanted to point out is that this work is work in progress. So I'm very much looking forward to all your insights and questions that we will be having afterwards. What this presentation is based on is a holistic overview of the obligation to produce national security evidence. And there are three different parts that this will treat. First of all, how an unwillingness or an objection to provide material is treated by the European Court. Secondly, how national security secrecy may impact the evidentiary standards and the requirements to substantiate a case. And thirdly, how the substantive rights protection may impact the requirement to provide national security evidence. And I hope to show by this that there is no reason, as we've also seen today, to sharply distinguish substance from procedure before the court, and also hopefully nuance and understanding which often is provided in the literature of national security before the court being mainly about giving a broader margin of appreciation to the contracting parties. And the reason why it's rather interesting to look at the national security case law in the question of the obligation to provide all necessary facilities and the evidentiary practice of the court is the national security cases often involve confidentiality claims and unclear facts. And this makes these type of cases a rather big proportion of the cases where the court is dealing with evidentiary questions. Because usually, as we all know, the facts often are well documented in the domestic proceedings underlying an application to the court. But to start with the first part of this holistic overview, the obligation to furnish necessary information to the court. So it's essential for the role of the court and for maintaining its functions that it can stress an unconditional obligation to furnish necessary information. Also, when national security evidence is at stake. And this provides the foundation for the rectitude in decision-making, which requires that you have both substantive law and to have the substantive law applied to the correct facts. And this is something, this obligation is something that you can see that the court is stressing quite thoroughly. First of all, it's not for the respondent government to establish what is relevant evidence. Secondly, an obligation to comply with evidentiary requests is established in the court's case law. Internal domestic law may not be invoked as a justification. The court here refers often to the Vienna Convention on the Law of Treaties. And then, fourthly, also a lack of safeguards before the court is no justification to not provide information to the court. So the court is rather firm here. And the way the court is then taking this into account in its case law is the failure to participate effectively in the proceedings is no reason to discontinue an examination. The court may draw inferences as to the substance of the claim, and this might also impact compliance with Article 38. So, in sum, the case law provides foundations for ensuring that the court's decision-making is based on correct facts, and that the court can fulfill its adjudicative role also when national security is involved. However, now we come to the other side of the coin. The court does not operate in a vacuum, and there are multiple ways in which the court can be showing procedural understanding of the confidentiality concerns of the contracting parties. So, for example, the court might not always request materials from the respondent government. A request may, for example, not directly relate to the national security materials, but to the way in which national security has been dealt with domestically. What I found quite interesting is also the fact that in YAM, the court directly accepted confidentiality concerns and due to the sensitivities assessed the compatibility of the convention without access to the material. So the court held that in some instances, even its own confidentiality guarantees may be considered insufficient to mitigate the risk of serious damage to fundamental national interests. This contrasts rather strongly with, for example, what the court emphasized in Al-Nashiri of its own confidentiality guarantees not being a reason why the contracting parties would not provide its information. But here it's also important to note that in the case of YAM, there had been a very thorough, or at least allegedly a very thorough review of the national security aim domestically, and it's related to Article 6 rights. There are also certain other procedural understandings of confidentiality. For example, under Article 38, the contracting parties may provide reasonable or convincing explanations for a failure to comply with evidential requests. This opens up a certain possibility, although rather strict or small. In Janowiak and YAM, these both indicate a certain possibility not to provide the court otherwise relevant materials when it has been sufficiently explained both how and why that conclusion was arrived at. So there is a requirement of a sufficient domestic procedure. And this is also something which is indicated in Danilov. Then in the evidentiary requests provided to the contracting parties, these might also show a certain understanding of confidentiality concerns. So first of all, the court might invite the government to provide a formal written explanation of the confidentiality. There might be a certain possibility to edit sensitive passages, or there might be an explicit guarantee as to the confidentiality in the request. There might also be references to the rules of court, based on which public access can be restricted to a document, and the court may hold in-camera proceedings. What I also found interesting in the case law is the fact that there are certain ad hoc arrangements, according to which the government's request, for example, not to provide all materials to the applicant was accepted in Sargsyan and Shirakov. This is something which goes against the usual procedure before the court, where both parties get access to all of the materials. Then in Shamayev and others, the president of the section was held personally responsible for protecting the confidentiality of any information that would be submitted to the court. So all in all, there is a certain rather ad hoc nature in the court's understanding of confidentiality guarantees or concerns, which might raise concerns to the predictability, maybe also procedural justice, but gives also the possibility of a certain flexibility of the court of requiring materials, and then also based on the decision or on the underlying facts of the case, taking them into account. What seems somewhat worrisome is that in YAM, there is a certain possibility for the court to consider its own confidentiality guarantees insufficient. And what also needs to be pointed out is that the understanding of the court often reflects a proceduralisation, such as requests relating to the procedure underlying a national security decision, or the possibility not to provide information being strictly related to the fact that there has been a domestic procedure looking into the issue. Now we come to the question of evidentiary standards. So as we've heard today, the court has a rather complex evidentiary practice, and the conclusions on how the court reviews a case is rather hard to draw, at least if we're looking at all the case law in general. So there is a certain flexibility, which is important also for an international human rights court. But in national security cases, one can see that the evidentiary approach of the court is impacted by the fact that it's bound to decide cases also without a substantial lack of evidentiary basis, and the importance of practical and effective rights protection, and it taking into account procedural imbalances between the parties. So what we already touched upon today is the fact that the court engages in a free evaluation of all evidence and a case-specific review. And in national security cases, this is important because domestically, there might be procedural barriers regarding state secrecy, and this is not anything that the court would be, that would restrict the court's evaluation of evidence. So an example of this is Nasr and Ghali, where the court emphasized, or the court did not disregard evidence which the domestic courts had disregarded. This is an example of how the court is upholding practical and effective rights. Then also, as O'Boyle just pointed out, the court is largely in this type of cases where there is secrecy involved, also using circumstantial evidence. So an example is Al-Nashiri, which also related to secret rendition. The court did not go into extensive fact-finding by itself, but based its establishment of the case largely on circumstantial evidence, including a large amount of evidence obtained through international inquiries, considerably redacted documents released by the CIA, public sources, and so on. So this exemplifies the importance of the convention, the way in which the court is keeping up with practical and effective rights. However, this is also an example of how there is a certain propensity of the court not to enter into fact-finding by itself. And there is also a possibility of the court to take into account previous cases and a certain tendencies of the court in its case law, as we've already also touched upon today. Certain points on the burden of proof. Generally, the court says that the burden of proof is not on one of the parties, but nevertheless, generally, the one who is alleging something has to prove it as well. So, affirmanti incumbit probatio, as we have discussed today. So, it is for the applicant to make a prima facie case. Also in cases which include national security. So, there might be a lot of applications ruled out as unsubstantiated due to the fact that there is no possibility to provide materials to the court. The instructions to the applicants still provide a possibility for the applicants to provide an adequate explanation for failure to substantiate its case. So what the prima facie case might mean is, generally it may mean establishing inferences with the right, but the onus of the applicant can be also on the applicant in situations where private and public interests are more finely balanced. And an example of this is IR and GT, where the applicants had to establish that the procedural guarantees under Article 8 required more specific information to be provided to them as the nature of the allegations against them and the purported threat to national security that they posed. On the other hand, generally it is for the government to substantiate a national security aim, because this goes in accordance with the affirmant incumbit probatio. The court may also take into account the applicant's difficulties in gathering and producing evidence, which relate to extreme secrecy. And important in this type of cases where the government, for example, or where the government can have exclusive access to information and fails to produce it, is the fact that it then is for the government to argue conclusively why the documents could not corroborate the allegation made by the applicant. So there is a change in burden and a presumption that the facts not provided to the court support the applicant's allegation. This is something which generally has been applied in Article 2 and 3 cases, but one can also find it in national security cases such as Nolan and Cole. And then there is also the possibility of the court to draw inferences from a failure of the government to provide information. So in this way, one might say that the court's evidentiary standards provide for a possibility to maintain practical and effective rights protection despite the lack of national security materials. This through broad use of contextual material, presumptions, inferences, and changes in the burden of proof. But these simultaneously also allow the court to efficiently review the case and focusing on its interpretation of the convention instead of being a court of first instance. And this role is something which also can be seen in the way in which the substantive understanding of the convention can impact the evidence that has to be provided to the court. So the starting point here is that the court has accepted to a certain extent national security secrecy in accordance with the fact that there is a general balance of interests which goes into the whole convention. So the court has held that the use of confidential material may be unavoidable when national security is at stake. This has to involve a certain good faith in the government, otherwise there would not be a possibility or a possibility of confidentiality. However, the court's review is not as simple as that, but it has, on the one hand, referred to it not being well equipped to challenge the national authorities' judgments that national security considerations arise, but instead of itself challenging such a judgment, the court has referred to the requirement that measures affecting fundamental rights must be subject to some form of adversarial proceedings before an independent body competent to review the reasons for the decision and the relevant evidence. So in many cases, the court might not directly go into or challenging the national security issue, but then looks instead at the procedure and the adequate domestic safeguards. So under procedural rights, the court's methodology is often expressed as that of counterbalancing procedural restrictions with other guarantees. And the court often scrutinizes the procedural safeguards instead of directly challenging the national security aim. Here it might be important to point out that this relates above all, for example, to Article 8 cases on the extradition of aliens, and in certain cases also on Article 6 cases which relate to procedural rights. So it's not anything which goes through the whole case law, but a certain tendency. And the rationale that we find here for the proceduralization is that domestic courts are better placed to assess whether national security is at stake. And sometimes, at least in Article 6 cases, the court does review this issue as a question of assessment of evidence. So, for example, under Article 6(1), only measures restricting the rights of the defense which are strictly necessary are permissible, but the court has also held that it's not its role to decide whether or not such a non-disclosure was strictly necessary, because as a general rule, it is for the national courts to assess the evidence before them. So there is a certain possibility to review a case before the court without access to the national security material. And this is something which you then can see also in the way in which the court is reviewing the case, for example, in YAM. But this is also indicated in cases such as IR and GT.
Jasmine, one more minute, please.
Yes. All right. So there are obviously limits to this. The court takes a rather balanced and nuanced approach. So when national security has no reasonable basis in facts or reveals an interpretation that is unlawful or contrary to common sense or arbitrary, the court will enter into a review. And also in many cases where the court is looking at the substantial guarantees, the court also points out that there is no material indicating excessive and unjustified secrecy. So there is a possibility to rebut this good faith presumption that exists in the case law. Then there is also, for example, under Article 5.4, the opportunity effectively to challenge the reasonableness of suspicions, or the obligation of the government to furnish at least some facts or information capable of satisfying the court that an arrested person was reasonably suspected of having committed the alleged offense. So the question of effective protection and the essence of the rights also comes into consideration. Nevertheless, one might say that in certain instances, evidence substantiating national security may be ruled out from the substantive convention protection through a review of the procedural safeguards, through better placed arguments, and a qualification as assessment of evidence. And this then in its turn restricts the contracting parties' corresponding obligation to provide such evidence to the court, exemplifying the inseparable nature of substance and procedure under the convention. So my argument here is that if the court earlier left a national security margin of appreciation, this is today increasingly reflected through structural protection and the convention's procedural bias, where emphasis is on the court not being a tribunal of fourth instance. And one might say that this case law in some way mirrors elements of what can be conceived as a perceived rise in the principle of subsidiarity and maybe a certain proceduralisation and structural review of convention rights. Thank you.